Good morning, good afternoon, and welcome. My name is Amy Howe. I am the co-founder of SCOTUS blog. Thanks so much for joining us. This has been a historic week at the Supreme Court because of the coronavirus crisis. The justices heard oral arguments by telephone for the first time, and on Wednesday, that included Justice Ruth Bader Ginsburg, who is 87 years old, participating in the oral arguments by telephone from the hospital where she was being treated for problems with her gallbladder. And those oral arguments were live streamed over the internet for the first time. So normally you have to wait usually a couple of days to hear oral arguments at the Supreme Court if you're not there in person, but this time you could listen live. Next week, the Supreme Court is going to hear oral arguments in a group of cases that have the potential to be historic themselves, involving access to President Donald Trump's tax returns. And joining me today to talk about them is my friend and colleague in the press office, Steven Mazie, who covers the Supreme Court for The Economist, but in his day job, he's also a teacher at Bard High School Early College in New York City. Steven, thanks for joining us.
Amy, thanks so much for having me. It's great to be here. And I just want to welcome everybody. Can you hear me? I'm getting an unstable internet connection notice.
I can hear you just fine. So
wonderful. So
great. And before we get started,
yes.
Before we plunge in, I would just want to say to everyone who's joining us, students, teachers, anyone else who happens to be joining us, that we are going to talk for about 20 minutes. And then we will take questions. So you have the opportunity at any point to ask questions using the chat feature, and then we will try to answer as many of them as we can at the end. So we're going to talk about a trio of cases, but there's, I think, a fair amount of background that would be useful in understanding the cases. And so Steven is going to go ahead and get started talking about the concept of separation of powers in government and how that is important to these cases that the Supreme Court's going to hear next week.
Yes, okay, thank you, Amy, and thanks to all of you for joining us today. A special welcome to students and to my students from Bard High School Early College. Welcome. When Amy and I were talking about how best to do this, we thought that it would make a lot of sense to situate these cases within the basic principle of the American constitutional system, which is separation of powers. So I'm going to share a little bit about that, talk to you about where this idea comes from, resolve what is a misconception, I think, for many people about how it works, and then just give you, for those of you who are not yet avid court watchers or court listeners, a little bit of a sense of how the Supreme Court operates. And I'm going to share my screen now to... The two blokes you see on the left here are the most, had the most impact on the American founders in terms of their conception of what the separation of powers should be and how the Constitution was ultimately drafted. So John Locke wrote the Second Treatise on Government in 1689, and he was really the first to explain why legislative and executive power should be in different hands. And he actually insisted that the legislative power should be the supreme power of the Commonwealth, which is allied with another fundamental principle, which is that of the rule of law, that everyone in society, including those in power, including the president, is subject to the law equally. And this might be reflected in the reality of the Constitution, which is that we have Article 1 addressing the powers of Congress, and we have to wait until Article 2 to find out about the presidency and the executive branch. So that was Locke. In the middle of the 18th century, a Frenchman, Montesquieu, added the judicial branch to this separation of powers analysis and sketched a three-way separation that directly inspired the framers. Here's one line out of his 1748 book, The Spirit of the Laws. Montesquieu wrote, "There can be no liberty where the legislative and executive powers are united in the same person or a body of magistrates, or if the power of judging be not separated from the legislative and executive powers. So 40 years later, James Madison, who was one of the three authors of the Federalist Papers, which were a series of 85 articles published after the Constitutional Convention, when the Constitution was drafted, to try to persuade people to ratify it. And each of the papers explained something else about how the Constitution, what the thinking was behind making a particular move in the way the Constitution was drafted. Anyway, in the 47th of those essays, Madison wrote, "The accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny." So combining all of the powers of government into the hands of one individual or into the hands of a body of individuals is what promotes tyranny, unjust rule, where it's those in power who are ruling in their interest rather than in the interest of the people. So just to summarize America's constitutional structure, when we talk about the separation of powers, we're talking about power being divided between the legislative, executive, and judicial branches. We learned that very early in our schooling and know that the basic picture is legislative makes the law, the executive carries it out, and the courts interpret the law and resolve disputes. But there's this other element, which is federalism, that power is divided between the federal government and states. So one of these is more relevant to Trump v. Mazars and Deutsche Bank, which Amy's going to talk about shortly. And the other, Trump v. Vance, has more to do with federalism and the extent of powers that the federal government has versus the state governments. Here's the misconception. The three branches of government are not completely separate. They are not insulated from each other. They are not islands. Some of you might be familiar with Schoolhouse Rock, which is a series of videos that came out in the 1970s. This is more my era and Amy's, but I think that a lot of students today still watch these on YouTube. A lot of these are great, but the video Three Ring Circus, I really cannot recommend. Here's a video from it. Where you see the three branches of government in their separate circles, in their own territories, really not overlapping at all. That's not how it works. Instead, the circles overlap. The Venn diagram here on the upper left-hand corner is more akin to reality. The line from Federalist 47 that I read to you earlier is usually where people stop, but as you go along in that particular essay, Madison clarifies that when Montesquieu said what he said, he did not mean that these departments ought to have no partial agency in or no control over the acts of the other. In fact, to take away the double negative there, the branches do have a certain degree of control over each other. That's the only way that checks and balances work. You can't check another institution unless you have some say over it. This was pithily captured by political scientist Richard Neustadt, who wrote a seminal book on presidential power called Presidential Power in 1960, where he says that it's not separation of powers, really. It's a government of separated institutions sharing powers. And a couple of examples of how that operates, the partial overlap. The power of lawmaking, for example, is shared between Congress and the president. Congress must approve, each House of Congress has to approve of a bill, and then the president has to sign it. The president may veto it, which is a check of the president on the legislative branch, but Congress has a check on that check. They can override that veto if 2/3 of the Senate and the House agree. There is one example. War making, waging war, there's another good one. The president is commander-in-chief, which means that he or she decides military strategy, where to send forces, when, but only Congress can declare war. Congress has the power of the purse to decide how much money to allocate to waging war. This is a fraught area of, as many of these are, a fraught area of overlap between the two branches. Impeachment, we've had an example of this recently. When federal officers behave badly, the House may impeach the president, or judges, and the Senate can remove them after a trial. We saw one of those two things happen this past fall. Treaties, presidents can make them, but they can't conclude them until 2/3 of the Senate agree. And now getting closer to the subject of our webinar, judges. Judges are appointed by the president, but again, the Senate must confirm all of those choices before they get to sit on the bench and get their robes. Now, once they are seated, judges have a lot of power, and this is where they overlap with the other branches. They may declare a law unconstitutional. They can say that an official action of a member of any part of the government is illegal or unconstitutional. And here we have the Supreme Court, the non-virtual one. Today, there are very few people inside that building. All the justices, except maybe at times for Chief Justice Roberts, are at home in their basements or in their living rooms, the same way we are, doing their work. And just a quick picture of what the federal court system looks like. There are 3 levels of courts. There are the federal district courts. There are 94 of those. This is where trials take place. If you're unhappy with the result there, you can appeal to one of 13 courts of appeal, known as circuit courts. And then if you're unhappy with the result there, you can appeal to the Supreme Court. But your chances of getting your case heard aren't that terrific, as I'll say in just a second. There are in all about 870 federal judges. 9 of those are the justices depicted in stick figure form on the bottom right-hand corner. Here are the actual justices. And I thought it might be helpful just to, if you haven't seen all their faces, to get a view of them. You won't be seeing them in the arguments next week, but you'll be hearing their voices. The man in the middle is Chief Justice Roberts. He'll call the cases to order. He'll ask the first questions. And then you see the justices arranged in order of seniority around him. Justice Thomas has served on the court the longest, and Justice Ginsburg next longest. So they go in that order. And then on their flanks, on the left and right, you have Justice Breyer and Justice Alito seated. The 4 most recent members of the court are in the back. They don't get chairs. Justice Sotomayor and Justice Kagan, who are President Obama's appointees, in the middle, and President Trump's justices, Justice Gorsuch on the left and Kavanaugh on the right, with their big smiles. So you'll be hearing from them, but you won't see them. They're keeping their faces hidden during this. All right, so one more slide on how the court operates before we get into these financial records cases. I mentioned that your chances of getting your case heard by the Supreme Court are rather small. There are every year only about 70 to 80 cases the justices choose to hear out of a pool of 7,000 to 8,000. After a case is granted, which means the court takes it onto its docket and agrees to resolve it, the lawyers then exchange a series of briefs, which are actually not so brief. They're long documents, which under current rules can go up to 13,000 words. And after the round of briefs is done, a few weeks later, there's an oral argument. This is what you'll be listening to. It's a little bit different version from what the court does when it's in the building. But what's similar is that it's just talking. There are no, there's no evidence presented. There are no witnesses. There's no jury. It's just the lawyers and the justices talking and elucidating and clarifying arguments made in the written briefs. The oral argument is normally 60 minutes long. The ones this week have been going longer than that, and I imagine next week's will too, since they're even more complex in many cases than the ones this week. After the oral argument, the justices meet in private. They discuss the cases, they vote, they decide who's writing, and a few weeks later, or a few months later, or as many as 9 months later, the court releases opinions. And that's just a little bit about how the court operates if you haven't been familiar with that process yet. And now Amy will talk you through the basics of these big cases coming up on Tuesday.
There are 3 cases that will be argued over 2 hours next week on Tuesday. The first two will be argued together. Trump versus Mazars is one, and Trump versus Deutsche Bank. And those two involve the relationship between the president and Congress. And then the second case that will be argued, the third case, the second argument is called Trump versus Vance. And that's the relationship between the president and the states. We can go to the next slide, please, Stephen. So back when he was running for president in 2016, and so many of you, this is a really long time ago, the president did not release his tax returns. And this was a little bit unusual for a candidate from either the Democratic Party or the Republican Party in recent presidential elections. People like the president or the person running for president to release tax returns so that we get the full picture of their finances, how much money they make, whether or not they have any sort of what we call conflicts of interest that might affect their ability to make a fair decision. But the president said, I'm not going to do it. And the reason he gave at the time was because he said his taxes were being audited, that the Internal Revenue Service, the government agency that deals with tax returns, was taking a closer look at his tax returns, and his accountants had said that he shouldn't release them. So this was just a tweet about the president's tax returns. So we can move on, but the tax returns are what are at the heart of all of these cases. So the first case, Trump versus Mazars, one of the committees of the House of Representatives, a committee called the House Committee on Oversight and Reform, issued what's known as a subpoena. That's a requirement issued by the committee for request for documents last year to Mazars, which is the president's longtime accountants, the people who help him prepare his tax returns, to turn over years worth of the president's financial records, including his tax returns. And the committee said that it wanted the tax returns because it was investigating whether government ethics laws were adequate, whether or not they're doing their job, or whether or not the committee might need to consider changes to government ethics laws. So that's the first case, Trump versus Mazars. Second case, called Trump versus Deutsche Bank. These were subpoenas, requests for documents from two different committees in the House of Representatives, the Committee on Financial Services and then the Intelligence Committee. And these committees sent subpoenas to the president's, some of the president's lenders, a bank called Deutsche Bank, which has lent the president and his businesses a lot of money over the years, and some of his other lenders, including Capital One, which is a big bank, seeking financial records for the president, his family, and his business. And they said, we want these records because we're investigating whether or not foreign countries like Russia have influenced the US elections and the US financial system. So then the third case is called Trump, so Mazars and the Deutsche Bank cases, Trump versus Vance. This was the New York District Attorney in Manhattan named Cyrus Vance was investigating with a grand jury. Grand juries can also issue subpoenas, these requests for documents. They wanted Mazars, the accountant firm, to turn over Trump's tax returns as part of an investigation into whether the president had violated New York law. And so the president's argument is that while he is president, he can't be investigated for violations of criminal laws at all. We can go to the next. So some of you, again, this happened 4 years ago, so some of you may not remember it. But during his campaign, he was giving a speech and Trump said that he could stand in the middle of Fifth Avenue and shoot someone and I wouldn't lose any voters. And so during the oral argument, this actually came up. Some of the judges said to William Consovoy, who was Trump's lawyer in the oral argument in the lower court, is that actually true? If he shot someone in Fifth Avenue, could the state of New York prosecute him? And so I'm going to play, just for fun, a little bit of a clip from the oral argument.
Local authorities couldn't investigate, they couldn't do anything about it?
I think once a president is removed from office, any local authority, this is not a permanent immunity.
Well, I'm talking about while in office.
No.
That's the hypo. Nothing could be done. That's your position.
That is correct. That is correct.
So even gathering documents.
So that was the answer that Trump's lawyers gave, is that while the president is in office, he could shoot someone in Fifth Avenue in the state of New York, couldn't prosecute him, couldn't investigate him. They said after he's out of office, that's a different story. But while he is in office, the state can't investigate him. And they said it's really important that states not be able to harass the president and investigate him, because imagine if you had all 50 states trying to investigate him. All right, we can go on to the next slide now. So next Tuesday, the first two cases involving the interaction between Congress and the president will be argued together for 1 hour. And so there'll be three lawyers. You'll hear the president's lawyer, you'll hear a lawyer for the House of Representatives, and then you'll hear a lawyer for the federal government, because in this case, the president it's his personal lawyer who's arguing on his own behalf that the House of Representatives has gone too far, that they don't have the authority to issue these requests for documents. The argument is that the House of Representatives can ask for documents for what's called a legitimate legislative purpose, if they're really doing this as part of their role to pass laws. But they say that that's really not what's going on here, is that they're really trying to act more like the police, more like what the executive branch's job is, than trying to pass laws. And then there's a lawyer for the federal government who will also argue supporting the president. And then in the second case, Trump versus Vance, there's again three lawyers. You have the president's personal lawyer, you have a lawyer for the federal government supporting the president, and then you have the New York prosecutor who will be arguing that the president can be investigated for violations of state law while he is in office. So that's what's going on. You'll have, as Steven said, a little bit over an hour of oral arguments at all likelihood. The justices have had to change the way that they do oral arguments a little bit because of the coronavirus crisis and because they are holding oral arguments on the phone. If you go to an argument at the Supreme Court, one of the things that people notice is that the justices ask a lot of questions. A lawyer who is arguing there will stand up. The traditional opening is, "Mr. Chief Justice, and may it please the court." And this year, the justices have allowed the lawyers who are arguing about 2 minutes to say, to make a little speech presenting their case. And then they start asking questions, and the questions can come fast and furious. And it's a format that would be very, very hard to do over the phone when the justices can't see each other. They don't know when another justice is trying to ask a question or when the lawyer who is speaking has finished an answer. And so to address that problem, the justices are taking turns. They start with the Chief Justice, and then they move on through each of the 9 justices in order of seniority, the amount of time that each justice has been at the Supreme Court. And each justice has approximately 2 or 3 minutes to ask questions, and then the Chief Justice moves on to the next justice. So it's a little bit different from the way that things would normally take place if they were live in the Supreme Court, but it's still a lot of fun to be able to listen to the oral arguments in real time. All right, so we have questions. The first question is, what happens if the president loses? Can I see his tax returns right away in the news? Stevie, you want to take the first crack at that?
Sure. Well, it depends which case he loses. If it's the Vance case, then what would happen is the documents that Cyrus Vance is asking for will go to Cyrus Vance, which she can use in a sealed grand jury setting, which means they won't be available to the public at all, or at least they'll be under seal until the president leaves office. With the other cases involving the House of Representatives, as soon as those documents arrive from the banks and from Mazars in the hands of the people who are running these committees, they could go on the House floor that day or the next day and read them out, so we could hear them. They won't be published in the newspaper until They are disclosed by members of the House who have access to them. But it's very possible that that the president wins one of the cases and loses the other, which would mean that if he loses Vance and wins Mazars and Deutsche Bank, then the records could get out, but only to the grand jury for the time being. Is that your sense?
Actually, we had one sign, at least from the Supreme Court recently, that could be a real possibility. Can you say just a second about that?
About the political question issue?
Doctrine. Yes.
Right. So this relates to the separation of powers argument and principle that we were looking at earlier. Just on April 27th, the court asked the lawyers who were arguing Trump v. Mazars and Trump v. Deutsche Bank to send in an additional set of briefs. So all the briefing was done, and they said, we want 15 more pages on the political question doctrine. Briefly, what the political question doctrine is, it's a way for the Supreme Court to avoid resolving cases. It decides sometimes that a case doesn't pose a proper legal question, but a properly legal one, but a properly political one, which should be resolved by the other branches, by the so-called political branches. And so if that's the case, then the court may say, we don't have jurisdiction to resolve this, and the courts below who thought they had jurisdiction to resolve this actually didn't. And this would be a kind of off-ramp for the court not to decide the merits of the case, but say, it's out of our hands because of the separation of powers, basically. We're not competent, we don't have standards which are manageable for us to resolve this case. That doesn't hold with the Vance case. They didn't ask for that briefing for the Vance case. But for the two cases out of the House of Representatives, there's at least a possibility they could resolve it that way. Those briefs are due tomorrow at 2 o'clock, so you can go and read them before the oral argument happens to get a sense of what the parties are saying. Just one more word, I did a little reading back to a 2011 case in which the political question doctrine came up last night. And Chief Justice Roberts, who wrote the opinion in that case, basically said that the political question doctrine is not there to serve as a crutch for us not to decide cases which have political import or political implications, or that we might want to try to avoid. We have to resolve cases that reach us that are resolvable. So these are very political cases. They're very politicized cases, but that doesn't mean they necessarily pose a political question that the courts can't adjudicate. Anything you want to add on that, Amy?
No, I think that was great. So, and I think there's two questions I think that sort of get at sort of what happens if Congress loses. Is that the only time Congress can investigate the president is during an official impeachment hearing? I think that will depend in large part on exactly what the Supreme Court says in its decision. Now, the Supreme Court has said, as I mentioned earlier, that Congress can issue these kinds of requests when they're for a legitimate legislative purpose, when they're really doing this as part of their efforts to pass laws. And so, Congress, the Supreme Court could, they could say that this is not the kind of dispute that the Supreme Court's going to weigh in, and that would make it much harder for Congress to investigate the president when it's not an official impeachment hearing. If they said something along the lines of that this particular request is not really part of Congress's efforts to pass laws, but here are examples of situations in which Congress could do this, then that would not necessarily ban future efforts to investigate by the president. It would just mean that Congress would have to be more careful in how it went about this in the future. But I don't know, Stephen, if you agree.
Yeah, I mean, I'm still, what happens as a result, if they do resolve this as a political question that they can't resolve, what does that mean? Does that mean, it could mean one of two things. One, that, we can't tell the president that he can block his banks and his accounting firm from providing documents to House committees, in which case maybe those documents will flow from those institutions to the House? Or does it mean that we are not going to enforce subpoenas that Congress tries to that Congress tries to use to get those documents? In which case there's no judicial muscle behind Congress's attempt to get those documents. So then I think it really depends on whether Mazars and Deutsche Bank and Capital One voluntarily comply with Congress's request for those documents.
Right.
Congress has its own ability to hold in contempt institutions that don't abide by subpoenas.
Right.
And
my sense has been, when I was researching this issue, that there are not a lot of, the Supreme Court has not had to address this question that often, in part because normally when this question has come up, Congress has issued these requests to the president. There's been sort of a back and forth process where Congress and the president try to negotiate a solution that everyone can live with, and that they, either they weren't able to negotiate or they didn't want to negotiate. There's a lot of complaints that Washington has become very polarized in recent years. Without sort of the muscle to backstop the threat, it's going to be harder for Congress and the executive branch to try and negotiate in the future.
Right. Although there's one feature of these cases, which I'm sure we've emphasized, which is that these are subpoenas to a third party. They're not subpoenas to the president himself. So he has no ability to say, I don't care what the court says, I'm not going to supply these documents. He's not being asked to. It's whether his financial, his lenders and his accountants are going to do it. And so there's less of a negotiation, I guess, than, with the Nixon tapes case, where, we'll give you these tapes, but we won't give you those tapes. That was a different sort of a process.
A final question: why do they want to see Trump's tax returns? I think that there is a legitimate legislative purpose in there, but I think part of it is I don't think it's a coincidence that Congress did not request these documents until there was a Democratic majority in the House of Representatives.
Right. It started in April of 2019, so it's been going on for 13 months now, and their claim is we have a number of bills we'd like to consider drafting and passing. And so we need this information to strengthen ethics laws and maybe prevent emoluments violations. But the response from President Trump's lawyers is, this is really a political stunt. They're just trying to harass the president. And there's a very blunt line in one of the briefs. I think it's in the Mazars reply brief. Congress or these committees in the House would undoubtedly like to have these documents, but they do not need them. And that, I think, is the crux of the argument we'll hear from them next Tuesday, that they don't need these to make law. They just want them, and maybe they want them to go on the floor of the House and read them out loud so everybody can hear them. Because clearly there's something the president doesn't want the American public to know about his finances. We don't know what that might be, but there's clearly something.
Yes. Well, thank you. Thank you very much for joining us. I hope everyone enjoyed this as much as I did. So the oral argument, just to recap, will be on May 12th at 10 a.m. Next week, we will also have a preview webinar on the faithless elector case for middle schoolers. And then we'll have a post-argument webinar with Steven Mazie again on May 14th at 12 p.m. Eastern. So thanks very much for joining us.
Thank you, Amy. Thanks, everybody. And please listen in on Tuesday. It should be a great argument for all three of them.